I've been a prosecutor. I've practiced as a defense attorney. I'm the past chair of the Board of Bar Overseers. I'm running to be district attorney because we need somebody who can lead the conversation at this critical point that we're at in the conversation on criminal justice reform. We need somebody who can talk about both safety and social justice in a way that's just absolutely never happened before in Massachusetts. And that's the primary reason why I'm running to be the next district attorney in Middlesex County. The primary role of the district attorney is two. One is to keep our communities safe, and the second is to be a minister of justice, right? To work in the furtherance of justice. It can't be just about getting convictions. It has to be thinking about the entire system and how it's functioning and whether justice is being provided in all of the many district courts and superior courts in Middlesex County. If you're not a person who's had perspectives from other parts of the system, it's very difficult to have a vision that might think about what can we do now? What are we doing now? How are we investing our resources? And is it working? Right now, the district attorney's office, for example, there are 35,000 cases a year in Middlesex County. Of those 35,000 cases, I can't tell you anything about who's being prosecuted, what they're being prosecuted for, or what the outcomes are. And yet we're investing millions of dollars in this system without absolutely understanding what the outcomes are. Are we any safer because of the way cases are being prosecuted? What other business, if you thought just about the criminal justice system as being a business, what other business do we run for decades without figuring out if all the money that we're investing in that system is actually keeping us safe? That's one part of the conversation. And the second part of the conversation is making sure that our victims are safe, that witnesses feel like they can be part of the system without fear of repercussions, and making sure that we're respectful of our defendants' constitutional rights. So you have that business aspect of it, and then the due process rights for defendants, and then the empathy that we need to have for the victims who are involved in these cases. So it's a role unlike any other role in government. It's a powerful position without any check at all, except by the voters, right? So the district attorney actually makes all the decisions about what cases are going to be prosecuted, whether the case ultimately gets diverted, whether it gets, whether there's a plea deal that's worked out, whether it goes to trial, and then when it goes to trial, whether if there's a conviction, whether there'd be incarceration or probation. These are all critically important decisions, and it's all held by the district attorney, not checked by the governor, not checked by the attorney general, not checked by anybody in the state house, only checked by the voters in Middlesex County. I can give you an example, if that's helpful, about how powerful the DA is and why we really need to start thinking about who the leader is in the district attorney's office. There was a case that came out of Middlesex County, a woman in Ashland who was beaten so badly by her partner that she was hospitalized. When she got out of the hospital, actually purchased a stun gun. And it was an intentional act on her part because she didn't want to shoot to kill the father of her children. But she needed to keep herself safe in a way that wasn't happening, that she wasn't getting assistance from the government. She eventually, a number of weeks later, was stopped and the police saw the stun gun and she was arrested for possession of the stun gun. This district attorney, the incumbent, actually charged and then took her to trial, and she was convicted of possession of a weapon. Not only that, it was fought to the appeals court. When she appealed, they fought to make sure that that conviction was affirmed. So the number one goal of government, the job of government, should be to keep our community safe. Not only did we fail this woman, did the incumbent fail this woman, but then the incumbent used her prosecutorial resources to charge and convict her. So those aren't my words. Those are the words of the Supreme Court. of the United States, because when this woman, her name is Jamie, appealed her case to the Supreme Court of the United States, they said that this woman was not kept safe. And that's by the incumbent. That's on the incumbent. So let's talk about a leader as district attorney. What could a leader who's thinking about justice do? Right? She's arrested. That's perfectly appropriate. She had possession of a weapon. But the first question could be, why? Why are you possessing this weapon? You're a victim of domestic violence. You don't feel safe. Can we get a restraining order for you? Can we help you get a restraining order? Do you need a safe house? What can we do to make sure that we're safe? Think about all of those resources that were used to fight a case all the way to the Supreme Court of the United States by the incumbent, instead making sure we could make sure that she's safe. When you're fighting all the way to the United States Supreme Court, what happens? Let's say that woman, she convicted, she happened to get a probationary term. She could have been incarcerated, right? Who's going to take care of her children when she's incarcerated? The man who beat her so badly that she was hospitalized? Is that justice? Is this what we want from our district attorney? So that sort of, in a nutshell, is the power of a district attorney. Get justice, keep somebody safe, or fight it all the way and make sure that that conviction is affirmed. I think that the voters of Middlesex County probably want justice rather than a conviction. And that's just one of the 35,000 cases that come through Middlesex County. Each and every single one of those cases has that kind of story behind it. So we need to elect a leader whose core mission is justice and empathy for victims rather than a conviction at any cost. That's an easy question for me to answer. The primary inspiration, and an inspiration for my campaign, is the Philadelphia District Attorney. His name is Larry Krasner. He was elected recently when the seat opened up because the sitting district attorney unfortunately faced criminal consequences and was convicted. Larry Krasner is a man who spent his life as a defense attorney. He actually sued the Philadelphia Police Department a number of times. But he has the vision and he has the backbone to say now is the time for criminal justice reform to be led by a district attorney. In Middlesex County, what's happening now? Our district attorney, as an example of how progressive she is, refuses to sign a letter that the other district attorneys signed that said that the criminal justice bill that was just passed shouldn't have been passed. She refused to sign a letter. Is that really enough? We need to have a leader who's willing to be proactive, who's willing to do more than not take an action to say she's progressive. So as an example of something I would do as district attorney that Larry Krasner has done is I would have no bail, no cash bail for low-level nonviolent offenses. Now you may have heard that the incumbent has a similar policy, came out with it in January, but she didn't define what she meant by low-level nonviolent offenses. I did a public records request, as I have done as a defense attorney, and said, you know, how did this policy get developed? And what I learned is the prosecutors in the office learned of the policy on a Thursday afternoon. 4 minutes later, the press release went out to the press. The policy and the press release were absolutely identical. Nobody had the definition of what was meant by low-level nonviolent offenses, so that means we can't hold her accountable. But worse than that, what it means is because she didn't train her prosecutors on it and didn't define it even for her own people who work in the office, the emails afterwards were, we don't know what to do when we go into court tomorrow because we don't know, the prosecutors in the office, what she means by low-level nonviolent offenses. So like Larry Krasner, I will define exactly what I mean by low-level nonviolent offenses. I will collect and release the data every 6 months so you know who I'm making bail requests on, who my staff is making bail requests on, what the requests are, what the outcomes are, and you can hold me accountable every 6 months on that data. That's not happening now. That's something Larry Krasner is a proponent of, and that's certainly something that I'll do as Middlesex District Attorney. When I'm fortunate enough to be elected district attorney and serve a number of terms and then leave office, I would want my legacy to be as the district attorney who looked at the criminal justice system, recognized that it's infected with racial disparities, and addressed that issue in particular. We know that we incarcerate Black people in Massachusetts at a rate 8 times greater than Caucasians. So we know the end result. We need to find out what's happening in the courtroom. And my legacy will be as the district attorney who recognized that and addressed it, and that hopefully we can start to have a justice system that doesn't treat different people differently. Well, it's not just the shooting of unarmed people. It's also the use of force. You know, claims of excessive use of force. We saw that recently too with the arrest of the Harvard student in April of 2018. It's critically important that we have an independent unit within the DA's office that is investigating both police shootings and excessive use of force claims. And part of that would be, and this is not my opinion, this is the opinion of the best practices of the Department of Justice. The number one goal is to get the protocol written and in place before an incident happens. Because otherwise, every time it happens, and it sadly is going to happen, we're reinventing the wheel. So just to use as an example, the student who was arrested at Harvard. I don't know if you saw that video that was widely distributed on social media. It was disturbing to see somebody who was punched after he had been handcuffed and was lying prostrate on the ground. What have we heard from the district attorney's office? Nothing. It's been, as we sit here today and talk about this, it's been almost 2 weeks and we've heard nothing. The police are investigating themselves. That can't be a satisfying outcome, and it shouldn't be a satisfying outcome for the public or for law enforcement. If we have a process in place, which I will do as district attorney, that says when there is an officer-involved shooting or an officer, a claim of excessive use of force by an officer, there will be a protocol that will be followed. It will be by a unit that has no conflicts, has never worked with this police department before. It will include outside community members who are part of this investigation, and it will be transparent so that you can hold the district attorney accountable and you can hold the police accountable. And for the people where it's proven to be justified, say in a case of suicide by police officer, that we understand that as a community. There needs to be both a process and a protocol in place, and then transparency after the investigation is done. There was that shooting in February of 2018 of a Reading man by the police, being investigated by the police. We don't know if the Middlesex DA has started a grand jury investigation. It's been absolute silence. It even took them a week before they said the man's name. This is not the kind of dignified process that we want to have. We're all human beings. Each one of us in this investigation demands dignity. The police officer, the defendant, the victims who see what happens. It's not happening now. And unless we actually get a written protocol in place that can be followed each time, we can't hold the district attorney accountable, or neither can we expect to hold the people involved in the incident accountable. So it's critically important that we have a Public Integrity Bureau that follows that kind of protocol. I'll create that protocol with the input of many different stakeholders in the community to make sure that we're running those investigations in an appropriate way, and then we'll be listening to feedback at the end of each investigation to make sure that we're doing that right and that people have trust both in law enforcement and in the system. That's not happening now. We need to change that. I found the report from the ACLU absolutely stunning when I learned about it. And in fact, it's been the basis of a Supreme Judicial Court case now called Commonwealth v. Warren, where the Supreme Judicial Court said that one of the factors for assessing whether there's reasonable suspicion to pat frisk suspect, it can no longer be if you're a black man and you've run from police, because it's such a common experience, life experience as a black man, and I'm speaking from the decision, obviously, not from my own experience, but that they will often be stopped so often by the police that the common reaction is to leave, to flee, and that fleeing cannot be considered consciousness of guilt or used in the decision to assess reasonable suspicion. So that's a whole lot of legal jumbo right there. But for me, what was compelling about the ACLU report was we now know that at the beginning of any interaction with what we'll call the criminal justice system, there is racial disparity. We also know, because of federal law that mandates the collection of data on incarceration rates, that the end of the criminal justice system is impacted with racial disparities too. So again, the fact that 8 times as many black people are incarcerated, 5 times as many Hispanics are incarcerated than Caucasians. Here in Massachusetts, right, where we think we're doing such a great job. So I now know, bookended, the beginning of the system and the end of the system is infected with racial disparities. What's happening in the middle of the system? I can't tell you, but neither can the incumbent, because all of the cases, all of the 35,000 cases that are working their way through the Middlesex County courts, I can't tell you the race, the gender, or the charges that they're being crimed with in any meaningful way. What does that mean? That means I can't tell you that the kid in Lowell is getting the same treatment as the kid from Weston. Absolutely couldn't. Even when I was a prosecutor, before I became a defense attorney, I knew I wanted to do the right thing. But if I'm working to resolve a case, let's say in the Malden District Court, and I don't know what's happening in the Air District Court, I can't possibly treat that person equitably. So even the people inside the office not knowing what happens across the system, it ties their hands from making sure that they're being fair and just and treating everybody equally in a way that means that the system, until we shine a bright light on the DA's office, the system is going to be infected with racial disparities. Is it intentional? I can't answer that question. I like to think that it isn't intentional. I know so many good people who are working in that office, but if we don't give them the data to see what's going on and what the right resolution is, we can't expect better from them. We need to demand better, and part of that is by getting the data and using it in a meaningful way to make sure that we're not treating different people differently in the courthouses of Middlesex County. I'm a very big proponent of gun control. I was proud to walk side by side with my daughter on Boston Common for the March for Our Lives, inspired by a 12-year-old. We're at the point where we have so failed on gun control that we need the children to lead us. Part of it is inspiring, part of it is frustrating. The fact that we can't even have fulsome background checks is shameful. And so the very first thing that we need to do is make sure that we have waiting times, that we have background checks, and that we have gun control in a really meaningful way. We do a pretty good job in Massachusetts on that. The individual law enforcement officers, the sheriffs and the chiefs, have pretty good control on that, but we can do more. I think the bill that Marjorie Decker has sponsored about being able to take, in an emergency situation, firearms away from people who are perhaps at very critical moments on mental health issues or substance abuse issues is very important, and I'm a supporter of that legislation. We need to have a district attorney who's not afraid of the NRA, who is willing to speak loudly and use the bully pulpit of the office in order to make sure that Massachusetts continues to be a leader on gun control. That hasn't happened yet. We need to do that. There absolutely is something that the district attorney can do about the overreach of ICE, going into courtrooms where people are coming because they've been victims of crime, because they're a witness of an incident, or because they're a defendant. So it's not just protecting defendants. It's thinking about what's happening to victims who don't come forward because they're so afraid of immigration consequences that they can't be protected. And they're members of our community. We have to have some empathy. The first thing that I'll do as district attorney is appoint a staff person as immigration counsel. An immigration counsel would have 4 different roles. The first would be to make sure that our prosecutors are educated about what we call collateral consequences. So how a case may impact the immigration status of the defendant or the witness or the victim in the case, in order to educate the judge and make sure that we're assessing the case appropriately so that it doesn't have unforeseen consequences, collateral consequences on immigration status. Also to reach out to immigration groups, both faith-based groups and community groups, to make sure that they understand that we have this position. But the primary role of the Immigration Council would be to make sure that for victims and witnesses who are involved in the system, there is a special application for visas called U visas and T visas. These are special visas that are available to victims of violent crime, typically domestic violence cases, and victims of human trafficking, who've been sex trafficked. We'll apply for those for the victims and the witnesses and follow that through. Because sometimes justice in a case may be to get that victim or witness special immigration status in addition to getting a conviction in the case. Or maybe we don't get the conviction in the case, but the most important thing is we've kept somebody safe. So I'm not saying that I don't want to hold people accountable, but I don't, as district attorney, don't have control over the federal immigration laws. But what I can say is the people in Middlesex County, all of the people in the community, should feel safe enough to come forward to say, I've been a victim of crime, I've been a witness of crime, because ultimately, if we allow that, if we support that, and make sure that that happens, we're all going to be safer. Let me just contrast that for a minute with what's happening now in the current administration. The step that she took, again, leadership by letter. She submitted a letter to the Supreme Judicial Court that supported a brief in one case talking about ICE. That's it. That's just not enough. We need more. We need to stand up against the federal immigration laws and say, we are willing to support the people in our community and keep them safe. And that's why my office will have an immigration council to make sure that everybody in the community feels like they can be part of the justice system without fear of splitting their family apart. The criminal justice bill that was just signed into law by the governor is an incredible step forward. Absolutely. The fact that it took us 10 or 20 years to get here is a little concerning to me, having been involved in the criminal justice system for such a long time. I'd say that the thing that I like the most about the new bill is the ability to give someone a second chance. There are people in the who've been involved in the criminal justice system who never had a first chance, right? When we talk about the way that the system operates. But the fact that it's easier now to seal a record, I think is an incredible step forward. And I have seen that from personal experience. I've had a client who had one conviction on her record. It was a felony conviction. She served her time, but then when she had children, she couldn't chaperone their field trips. She had served her debt to society, and now because she had a felony conviction, she couldn't get a job, she couldn't chaperone her children on field trips, she couldn't even teach their Sunday school class. Now, this can't possibly be the right result. So that is definitely a step forward with the criminal justice bill, that we can seal and expunge actually some crimes. That's wonderful. What would I have done differently? One of the things that I was most disappointed in, although not surprised, is the fact that the bill did not raise juvenile court jurisdiction to the age of 19. We just recently, within the last 4 years, raised the age 1 year. And what it indicated to us by including a whole nother year of, young adults, juveniles into the system, is that we recognize that they can be rehabilitated. Their cognitive development has not ended yet, that this is a chance for us to stop their involvement in the criminal justice system if we give them the right programming, and that happens in the juvenile court. So as district attorney, because the legislators couldn't or wouldn't raise the age of juvenile court jurisdiction, I'll have a bureau, a juvenile and emerging adult bureau, that will treat cases with emerging adults that's up to the age of 24 as if they were in the juvenile court. The first step will be screening the case to see what supports that person has, why they took these actions, what programming can we give that person, whether they need substance abuse treatment or mental health treatment, whether they need job training or education or all of the above. Because I guarantee you, every dollar we spend on these programs will absolutely save us tax dollar money. So let's just say I'm a progressive Democrat, but I'm happy to talk to a conservative Republican. I will tell you that if we have those programming, for every dollar we spend on that, we're probably going to spend we're going to save $2 or $3 on incarceration rates. It shouldn't be that the best programming is available to those folks who have been convicted and incarcerating. And that's what's happening now. It's just a foolish way to throw away money, and it's not making us any safer. If we got a kid, and I define a kid more broadly than the state legislature does, if we had somebody under the age of 24 and we give them job training, we treat their substance abuse, we treat their mental health issues, we give them an education, right, in a way that somehow they escaped those benefits before. If that happens, the chances of that person reoffending drops dramatically, absolutely dramatically. Can I tell you how much? Guess what? I can't, right? Because the district attorney doesn't collect any data or release any data on any of the diversion programs that she has now. So I can't tell you what works in Middlesex County, but neither can the incumbent. So we need to invest more money in those programs, and we need to track the programs and make sure they're working. There's no other business in the world where we've invested hundreds of millions of dollars in the criminal justice and the prisons and the jails without actually looking at outcomes. So let's be smart and sensible about what we're doing with our tax dollars and make it work effectively, because ultimately justice is actually good government, and that's what we need to be thinking about. That's how a district attorney can lead. That's not happening now. That's why you need to get out and vote on September 4th for somebody like me who's willing to be a leader on this conversation instead of waiting for the legislature's great work that they did. But let's not wait another decade or two to make more reform. Let's make sure we're working tomorrow to make our system better. We deserve it. Any change is challenging. Doesn't matter if you're a chief of a police department, or you're a district attorney, or you're head of the public defenders, or a judge on the bench. Anytime you are a proponent of change, you are challenging people and asking them to really look at the status quo and say, how can we do this better? A big piece of that has to be the funding aspect of it. So there are a couple of ways that I'd like to approach that. One is, of course, relationship building. I don't want people to think that these reforms are soft on crime. They're smart on crime. We need to figure out, how do we keep people from reoffending who are part of the criminal justice system now? If we don't tackle that question, we are never going to actually have a safer community. And that's the number one conversation that we need to have. There are so many great police chiefs in Middlesex County who want to be part of that conversation. So I'm not worried about building those relationships. We have a sheriff who has, who really is very progressive and has some amazing programs in there. But again, we shouldn't wait until somebody has a conviction, is incarcerated, before we allow these people to have help and programming. The money is tough. And part of the criminal justice bill that was just enacted and signed into law by the governor, the big piece that was lacking, of course, was the funding for all of these great initiatives. I'll have a staff person that will only be responsible for applying for grants. So how does that work? I'll give you an example from the days when I was a prosecutor in Boston. I was head of the Conviction Integrity Program, and we needed people to do the work of looking at these claims of actual innocence, to make sure that people had gotten a fair trial and that they have the forensic testing to make sure that a conviction actually has the integrity that we think that it does. I was part of a team that applied for a Department of Justice grant. It actually funded 2 staff members and a number of resources like photocopy machines and scanners and laptops, so that we could track the cases and make sure that we were screening the cases appropriately and had the end result that was justice. What happened in a number of those cases? We actually agreed to forensic testing that was paid by the Justice Grant, and the result came back that the defendant was actually the perpetrator. Sometimes it came back not. But here's the situation. Justice was done with both of those results. When the result came back to the defendant, that actually gave me solace, right? We had the right person and we did the right thing. Justice was done. When the results were inconclusive or came back to another person, then we dealt with that in litigation, and sometimes actually vacated convictions based on that. So we need to have a more innovative approach, and that means having dedicated staff to making sure that we apply for grants, that we get money outside of tax dollars, and that we're working with academics and foundations in order to make Middlesex County a leader in the nation again, in the same way that it was in the 80s, in a way that it hasn't been in a decade.